Well, good afternoon, everybody, and welcome to the latest TMC Connect installment today. Been a great session involved with our longtime partner at Johnston Thomas, and we're going to be focusing today really on mitigating buyback requests and winning repurchase fights. As a precursor here, we have this session hosted as part of our 12 days of TMC virtual year-end event in December, and actually just dropped a link in the chat for anybody that would want to view that on demand here. That was the condensed version of today's discussion, as we only had a 30-minute time frame there, but just based off the feedback really out there to the network, we wanted to bring this discussion back into the mix here to allow James, our esteemed network expert here, be able to do a much deeper dive on the topic. And so we are excited to roll that out to you today. And then I'm just realizing, James, I sent that chat link just to you for the on-demand session. So let me drop that again in here for our entire audience today for this discussion. But leading us, I want to formally introduce longtime TMC preferred partner and great friend of mine within network here from Johnston Thomas, attorneys at law. We have their mortgage banking practice chair, James Brody, joining us today to lead this discussion. So, James, I will go ahead and start to share out the deck, but I will let you start to take it from here.
All right. Well, thank you very much for the warm introduction, Tom. Much appreciated. Good morning, everyone, or good afternoon, as the case may be. As Tom mentioned, my name is James Brody. I'm the chairman of the Mortgage Banking Practice Group at Johnston Thomas. And today we're going to be talking about the comprehensive review of mitigating buyback requests and winning repurchase fights. Although there's only so much ground that we'll be able to cover in the hour today, that we have a lot of, I'm going to be confident that you'll find the material very informative as we continue to navigate the ever-changing world of repurchases. If you didn't have enough problems with the high interest rates and the business dips, unfortunately, I hear every other day about another lender that's either being acquired or has decided to, wind down until better days come. Now we have, again, a resurgence of the repurchase fights that we saw, in the wake of the 2008 financial meltdown. So we'll talk about, how to handle those claims, some of the defenses, how best to mitigate your exposure, and how to look at going after other third parties who may have culpability. But before we go ahead and do that, I'll give you the standard proviso on the next slide, please. At the end of the day, please don't take anything that is said today to be specific instructions or legal advice for your particular concerns. If you do have follow-up questions, I will certainly be happy to address those. As I think many of you know, if you are a member, we give 2 half-hour complimentary free consultations. So we can use one of those or both of those to address any questions that you may have on facts and circumstances and legalities that are particular to you. With regard to, the next slide, and just talking a little bit about the firm, while we certainly had our roots in these repurchase fights, we had handled, maybe 10 or 11 lawsuits against City Mortgage in St. Louis, well over 10 or 11 with RFC ResCap in the Minnesota litigation, and then probably around 70 of the lawsuits with regard to the Lehman cases, on top of the 50 or 60 mitigation matters that we had handled. So we do have quite a bit of background and skill and experience with regard to the repurchases, but nevertheless, with the market the way it is, we also have a wealth of information and assistance when it's whether it's loan officer compensation, trying to put together MSAs. And I think as Tom will announce either during this webinar or subsequently, we're going to put on another webinar about how to maximize profits and minimize expenses, and to do it in a compliant way, and that will be next month. So without further ado, Tom, I don't know if you want to make a couple of comments with regard to the slides on TMC, and then we can launch right in.
Yeah, happy to do so, James. I will skip over the introductory slide of myself here, but always appreciate the opportunity here around the collaborative. For those not familiar with TMC, we are the nation's largest independent mortgage cooperative. We are specifically serving the mortgage industry, really dedicated towards bringing together, whether it's community banks, credit unions, or independent mortgage makers, to be able to work together in an environment where we're able to leverage 70 best-in-class preferred partners within our network that have premier industry solutions and best-in-class benefits specific to our members. Obviously, it's tough times out there in the current marketplace. So, really, we're designed to look to help to level the playing field for, the smaller mid-market lenders out there to be able to compete against the largest lenders of the world, not only through pricing and solution benefits, but also through a host of different peer-to-peer networking forums throughout the collaborative, whether it's our 2 in-person conferences annually, a host of departmental working groups focused on different role functions within a lender's organization, as well as collaboration lab summits for C-suite executives to be able to get together with peers with lending institutions that don't directly compete but are similarly organized as themselves, to be able to do really mind share of best practices and ideas, different things they're implementing to help make their business operation function more efficiently as well as more profitably. And really, the other thing I'd mention here is just the newest benefit of the collaborative, being our TMCU offering, which I'm going to have to get you an updated deck here, James, around that. But really a unique opportunity in the mortgage marketplace where we're driving feedback direct from our members and partners around where there may be educational opportunities within our industry to help our mortgage professionals and grow them in their role or roles they're looking to transition into in the future. So great content. If you get the chance, check us out through the Mortgage Collaborative website. It's called TMCU, and we're constantly creating new educational courses designed for really mortgage professionals across the board to empower them within their careers. And last plug I'll make here, just with our biannual member conference slide on the screen too. For those members on the line of TMC, if you haven't registered already, definitely jump on it, as our early bird lender registration expires this weekend for our upcoming conference called Stay Classy with TMC in San Diego. And that's March 5th through the 8th. We've got the agenda now live on the Mortgage Collaborative website too, so you can see a great host of content that we've got available for you coming up here in March. And any non-TMC lenders on the line here, if you're interested in attending the conference, certainly would love to connect with you offline to tell you more about the benefits we bring together with TMC, and see if we can have you come join us in San Diego. Coming up in less than 2 short months here. So before I turn it back to James to kind of go over to the agenda, he mentioned it briefly, and I'll drop it shortly in the chat. Just a link to be able to register for our upcoming webinar here in early February, the 4th annual TMC Johnston Thomas Regulatory Roundup. And as James mentioned too, really focus this go around heavily around cost saving solutions or financial related items as relates to LO comp and other pertinent regulatory related topics that are going to help you operate more efficiently and hopefully more profitably in the year of 2023 and beyond. So to our members on the line, if you're not working with Johnston Thomas, highly recommend you do so. Certainly have a ton of clients within our network that work directly with James and his team. And a unique benefit that Johnston Thomas puts forth for all TMC members, whether they're a client or not, is the ability to connect with James or turning on his team with a 30-minute, actually a pair of 30-minute consultative discussions on an annual basis. So I know there's some folks out there that get Larry to pick up the phone to talk to an attorney that they're instantly going to be billed. Not that case here with our partners at Johnston Thomas. They really want to be a true collaborator with our members, hear the challenges you're facing, and hopefully be able to offer some resources, guidance, and help you along with your challenges. So on that note, James, always appreciate it. And I will turn it back over to you to take it from here.
Well, again, thank you very much for that, Tom. And, along with the cost savings issue, a big thing that we'll also be talking about is various employment issues, because as part of this downturn, people are getting laid off. LOs want to, know where their next check's going to be. And a lot of those have been increasing as well. But without further ado, getting to today's agenda, I'm going to briefly talk about, the current repurchase trends, the ones that we saw following the meltdown and the ones that we're seeing right now. Second, we're going to talk about how to go ahead and pick your investors, how to set yourself up for success. Now, it may not help you immediately with regard to everything that's happening right now, but making sure that you lock down good and favorable contract terms with your investors and your warehouse banks, your brokers, your title companies, all of that is critical for you to mitigate your future exposure, because for anyone that's been in this industry for any significant amount of time, you know that these things happen in cycles. Following 2007, 2008, wave after wave after wave of repurchase demands, then they slowed down, and now they are again picking back up. And we'll talk more about that as we go. Reserves and buyback insurance, basically, again, how to set yourself up for success and not get caught in a position where you don't have the funds to deal with the problem that may be encountered, don't have an insurance policy to deal with it. Next, we'll talk about briefly how to address incoming repurchase demands, how to set up your shop to deal with those. Third-party loss mitigation strategies. That really comes down to going after the third parties who are culpable, who have culpability, whether that's an insurance policy, whether it's because someone committed fraud, whether it's someone committed a breach of contract. I want to make sure that you know that if you get hit with a demand, it is not just, okay, it's either I pay or buy this back and or nothing. In many cases, you have the ability to seek recourse against third parties. And if you can save a relationship and deal with a demand by reaching your hand into someone else's pocket, someone else who has, more culpability, all the better. That also gets to the litigation and settlement of repurchase claims. What happens when you get a claim? Maybe you have bad facts, maybe there's bad law, maybe you don't care about the business relationship, but as everyone knows who has dealt with attorneys, these things can get really expensive. So it's always better to have a good game plan in place and figure out how best to move forward. Next slide, please. So with regard to the current repurchase trends, what we saw in the post-meltdown was that they were mostly product-based. I mean, they were liar loans, Nina, Ned, all of the, anything that had a no in front of it, no income verification. Those were the ones that were primarily being pushed back. Unfortunately, the investors knew about the problems that were going to be happening when they had such a product. But at the end of the day, after years and years of litigation and going back and forth, those have finally died down. Whether or not we'll be dealing with these Nina loans in the future remains to be seen. Now, the repurchase claims that we've been seeing, with the back in 22 and now moving into the 23 year, they regard a lot of underwriting issues, processing errors, compliance related issues. And, we also have to deal with loans that had been modified during the pandemic. A lot of loans are coming out of Wells Fargo right now, and many of them have been modified. So, one of the things to look at is, do we need to go ahead and buy back a loan that doesn't have the same terms is that which we had originally originated. So that's kind of what we're seeing at the moment. On the one hand, it's better than the ones that we saw back in the wake of the financial meltdown. And that's because, you're dealing with more meat on the bone. I mean, at the end of the day, if you have a loan and a borrower said, hey, I make this, and you didn't check whether they made that, most of the LPAs, loan purchase agreements, had some sort of trigger mechanism where you had to buy this loan back or do an indemnification. Now, with regard to the parties that we're seeing, it had previously been, Citi Mortgage, JP Morgan Chase, of course, Fannie, and many others. Now we're starting to see a lot more from Freddie Mac. We are starting to see a lot from Wells Fargo. We've got some big litigation that we're handling against the FDIC that is finally pursuing those WAMU claims from, I don't know, as 15 years ago. So you also have PennyMac and more. So the parties have kind of changed. And what we saw back at the initial iteration is that, Citi Mortgage and others had been taking a retreat from the correspondent business. Well, now we see Wells Fargo doing that. And that is maybe one of the motivations, because they don't necessarily care as much about that business relationship as they may have in the past. Although my personal opinion is that they have been kind of a bully all across the time period. But again, that's just my view of it. Next slide, please. So as far as preventing, buybacks and preventing problems related to buybacks, you really need to start off with your underwriting staff. Make sure that they are fully trained, especially for some of the more complex loan products and situations. It's a lot more motivation right now to get deals closed because, everyone wants to make a paycheck. And times are a bit tough, at least at this moment, and hopefully that will change here soon. They need to make sure that they're looking over all of the related investor requirements and making sure that all program requirements have been met, are met, and that will go a long way to protecting your company as time continues. Sometimes fast does not equate to better. In many cases, that's not the case. But you want to make sure that you have a strong team of talented professionals who are doing their job and know the products and know the requirements. Next slide, please. Now, as far as being effective, you want to make sure that you have in place a formal repurchase review process and, somewhat of a template for defending against these, because depending on how many you get, it's always better if you can handle some of these internally, save yourself some money on attorney's fees that you'll likely never get back. Nevertheless, if you have a grouping of them from one particular investor or there's a lot of money on the line, let's say that there's a $300,000-$400,000 loss, it may be better to seek out counsel so that you can put your best foot forward right at the front. But if you have one that's a $20,000-$30,000 potential loss, you may want to consider whether or not that should be sent along. So making sure that you know which ones to send out, which ones to keep. Now, making sure you also have a way to track data carefully and identify successes and problems that you've had in prior repurchase issues or in dealing with particular investors, because that's all good data that you can harvest to dealing with them in the future. And you also want to know about your business relationship. Do you sell a lot of your loans to one particular investor? Do you have a good relationship with any particular person, maybe in the C-suite? You want to make sure that you leverage all available resources. Let's see here. Establishing a review process, really depends on your unique business factors. Do you service? Are you wholesale, retail? Are your warehouse lenders also your investors? So you want to take a pragmatic look at who is going ahead and buying your loans. What has been your experience with them in the past? Making sure that you have, certain points of contact to go ahead and put together the dates and the deadlines, because whenever a repurchase demand is issued or a make-whole demand is issued, you have a set period of time under the MLPA and or a seller's guide that says when you need to respond. So you want to make sure that things don't get lost in the shuffle, because if you blow one of these deadlines, even though it's not technically a statute of limitations, that will be an argument that the investor can make. Hey, look, we complied with the process. We sent you a demand. We laid out the allegations. You failed to respond. Boom. Go ahead and take care of this right now. And it may be one of those big ones. So you don't want things to get lost in the shuffle. All right, Tom, next slide, please. Picking your investors and negotiating terms. Look, you know who you have good relationships with, who treats you right, your company right, generally their reputation. Now with like Wells Fargo, I mean, so much for some of those business relationships. I think everyone's going to need to start looking away. But the focus here, outside of knowing the various investors, is knowing your contracts. In many cases, lenders go ahead and just sign on to these MLPAs, sign on to the seller's guides, and they think, look, this is the cost of doing business. Let's just get it done. Well, I can tell you that is absolutely not the way to go. What you want to do, and maybe this is something that we can talk about. We have some materials that we can provide on how best to negotiate your MLPAs and seller's guides, because if you ask for 100 changes and you only get 5, and say you're just a small shop, you have no business leverage, if you get 5 changes, that's going to still be a better deal for your company if and when you need to rely upon that, whether it's putting in terms like materiality, so that not any small nitpicky problem can be used to have you buy back a loan that's going to cause you a significant loss. You also want to make sure that you're dealt with fairly when you're negotiating these. The last thing you want is to have a huge business relationship and be treated unfairly. For instance, there are some investors who have mortgage loan purchase agreements, and I'll just say MLPAs, that have things or provisions that contain language like, hey, you agree to waive any defenses that you have. So if they make a demand and you have a way to dispute it, you may have waived that. What kind of relationship is that when you are, working with someone and they say, look, we don't care about whether legal defenses you have. At the end of the day, if we tell you to buy a loan back, you're going to do it. That's not a way to do business. That's not fair. That's not in the spirit of a true business relationship and partnership. So we always look at those types of provisions. Another type of provision, and might address it a little later on as well, is a lot of investors have unilateral attorney's fees provisions. So this was a big one with Lehman. In the Lehman cases, if you were to win your case and defend it, and you had to spend a lot of money doing that, you would end up winning, but you would have all your attorney's fees over years of litigation, and it would be significant. On the other hand, if Lehman prevailed on one of their claims, they could recover from you not only the damages, but they could also recover from you the attorney's fees. So they get their attorney's fees if they win, you get nothing if you win. Usually it's something good to have, because if you say, look, you've got a bad case, if you go ahead and push this case and I prevail, you're going to have to end up paying me. And that helps to settle cases. But if you don't have any of that business leverage, even if you win, they're scot-free, that's not giving a lot of incentive to try to get these cases resolved. So you want to make sure that in the agreement, if there is a provision that says unilateral attorney's fees, that you make it reciprocal. And that's when we're negotiating these for our clients. We tend to start off, do a red line, reach out to the investors, say, here's our red lines. They come back, say, no, yes, maybe. You hop on the phone, you walk through them, and you come out hopefully with a much better agreement than you would have gone into but for that process. Okay. Indemnification provisions, look, those have the biggest potential for future liability. They're frequently litigated. Repurchase provisions, obtain a provision that allows for notice and an opportunity to cure, which most, I think, have. Now, one of the things that you want to look at when you are, when you receive a demand, and let's say it's a repurchase, well, are you in the business of servicing loans? Do you have the ability to go ahead and take a loan and service it compliantly without getting in trouble? A lot of times, investors, if they file a lawsuit and it's at the repurchase stage, they may try to do specific performance. However, specific performance, meaning that they can force you to buy a loan back, may not be successful, because what generally courts don't like to do is to force some type of behavior if money damages will be an adequate legal remedy. Now, there are ways to go ahead and negotiate around repurchases. Maybe you have an indemnification in lieu of repurchase if the loan is current. Hey, if this loan stays current, these are good paying borrowers. The issue that you pointed out, while it may technically be used as a basis to push something back, this loan is a good one. And so if you keep it and if it performs for the next 12 months, maybe we can walk our separate ways on that one. If it defaults during that 12 months, well, I'll go ahead and agree to pay you or do something. But at the end of the day, the last thing you want is, again, to take that onto your warehouse line, unless you're in the business of servicing loans, unless you can dispose of it. Sometimes you get a buyback and there's equity in the collateral. And at the end of the day, it's just a pain. Well, that might be reasonable to go ahead and take that back, get rid of the property, liquidate it, and then be done with it. Preserve your business relationship, avoid a lot of losses, avoid attorney's fees, and all of that. Offset net funding. One of the things that we used to do, it hasn't really come up so much lately, but when we would have a settlement agreement and things were tough, we would have some sort of a BIP clip arrangement where you agree to give them volume production. They take the losses out of that production by a certain amount of BIPs, and then you pay it off so that you don't have to reach money into your pocket. Now, whenever you're looking at the investor's ability to offset themselves, you want to make sure, again, that your MLPA, your seller's guides, has a proper notice, a chance where you can cure that, and hopefully some sort of cap that you can put in. Again, that will help you and your companies as you navigate this issue moving forward. Okay, so reserves. We haven't talked with our clients a lot about this, but it certainly was the case that questions come up. Hey, look, we are going to have to deal with these repurchase claims at some point in time, whether it's now, whether it's later. How best to prepare for that? Well, the best way to do it is to make sure that you are properly setting your reserves. What is your risk level? Do you know, based on your history, based on current events? Maybe consult with counsel, maybe consult with your CPAs, get a read for the industry, and make sure you sock some money away so that if and when these do pop up, as they will at some point in time, you are not having to dip into something that is not already set aside to deal with issues like this. Now, what are the reserves levels? Again, comprehensive risk assessment, problem loans, average repurchase loss historically. And I tend to say to err on the side of being conservative. Nevertheless, when you're not funding a lot of loans and you don't have a lot of spare capital, that may become difficult. Now, what's an alternative to setting aside those reserves, although it might be more additional as opposed to alternative, is that you can look at private market insurance that could cover against repurchase losses and prevent the tying up of funds. There are different policies to help. There are reps and warrant policies, but one of the things that I always do, whoever you're looking at on repurchase insurance, is that you ask them what their claims payment experience and history is. Do they pay out on a lot of claims? What is the limits? Sometimes if you have $40,000 or $50,000 of coverage, that's not enough. Maybe you need more, but it's definitely something to evaluate as you go, and you want to make sure that you are adequately protecting your companies. Next page, please. Okay, go back one, please. Oh. Okay, So there we go. When you're going ahead and when you receive a repurchase demand, you want to make sure that you are asking for specific documents that are tailored to the specific issues, for the repurchase demand. Be consistent and be persistent getting all this information, because really this is what's going to be helping you is making sure that you have all the documentation that you need in order to evaluate these issues. Again, it may seem like overkill, but I can tell you that it's always the devil that's in the details. And if you want the best chance of the best resolution, whatever that resolution may be, whether it's avoiding a buyback, avoiding indem, or having the tools to negotiate a good deal, you want to make sure that you are asking them for that information. Now, the clock on a demand should not start until you get all the information that you need from the investor. Now, I mentioned MI because, well, we haven't seen it much as of late. We used to see a ton of repurchase demands that were triggered by MI rescissions. We had, in fact, handled one where there was an MI company that did 300 MI rescissions that were not correct. And that was a fairly large piece of litigation that we had handled out in Florida. Get all of the data for every loan. Don't piecemeal it, because the aggregators will bleed out the info and counter your every rebuttal with a new issue to justify repurchase. Get it all at once, and make sure you put your best foot forward. Now, make sure you also establish your own internal timelines for getting info that you control and review. Try to work with your aggregators, as I mentioned at the outset. A single point of contact is always best, especially if you get multiple demands. The last thing you want to be doing is working with one agent or one point of contact on 2 loans, another on 3 loans. It's always better if you can combine these, because when you are negotiating these as a whole, you have the ability to get a better deal overall. Now, some loans may have good defenses on one, and you can get rid of that one to get rid of another one. But if you're handling a multiplicity of demands, you should be able to get a better negotiated resolution settlement by settling them all at one time, unless, like in a particular case I had where we had many of them that we've been handling, and there was one that had a massive loss of like $800,000, $900,000. Then it may be good to segregate out those ones, get rid of the bulk of them, and depending upon the facts of the large one or large ones, that those be separated so you can mitigate your risk of litigation, mitigation, and then resolving those. Okay, next page, please. Many aggregators are reluctant or even refuse to provide lenders access to the servicing records on loans subject to repurchase demands. Usually they cite, hey, look, this information is private. We can't go ahead and provide this to you. And, at the end of the day, you start scratching your head. Well, didn't I originate this loan? Wasn't all that information to me? Didn't I sell this to you? And now you're telling me that it's private, but yet you want me to buy this loan back? So, that's something that, they tend to come up with, especially when you're asking for the servicing records. But the servicing records are, huge. You want to make sure that you get those. And if you're not getting all the documentation that you need in order to evaluate your claim, you're putting another defense in your path or in their path. To say, look, they made this demand, they made this allegation, but they refused to give me the information needed to evaluate it, to let me know whether their allegation has merit, or whether I have a defense. It's not something I enjoy, but at the end of the day, you want to go through, and it's very easy to look at the GLBA private and argue, look, the GLBA privacy protections do not apply to the lender-investor relationships based on the exceptions that are contained therein. Both parties have an interest, and the lender has a pre-existing business relationship. Simply doesn't cover the NPPI or non-public private information in a case such as that. So make sure you get those servicing records. Next slide, please. Okay, appraisals. Again, I haven't seen a lot of appraisal issues come up, although they have come up many times over the years. An unsupported appraisal used to be a fairly common repurchase allegation. And the things that you want to consider when fighting back an allegation of an unsupported appraisal is, what about the retrospective review appraisal? Now, when you order a retrospective review appraisal, and you want to order a retrospective review appraisal unless the loan really is a fairly recent one, and then you might be able to get away with something else. But you want to have an appraiser that you trust go back, look at the time of the origination of this loan, and whether or not the value was supported. Now, what happens if you order it and it comes back and it's bad? Well, if you end up litigation, that information will have to be provided to the other side, and you will basically be shooting yourself in the foot. Whereas if you order it through your lawyer, it may be considered as work product. And if it turns out to be bad, you won't have to disclose it. Maybe just order another one. Maybe you end up going that route. But the last thing you want is a piece of paper saying that the investor is right, or maybe the investor, their appraisal was even better than what yours says. So if it turns out to be good, then you can go ahead and get it out of that privilege status, provide it and say, look, here's the retrospective review. You said that the value was not justified. We looked back at every single angle of the original appraisal, and it was indeed. Now, you want to analyze the appraiser's scope of work and the comparable section, and you want to utilize USPAP. Many times when an investor goes ahead and makes an appraisal issue and forces a buyback because of that, they're not necessarily looking at the USPAP standards. And that's something that you want to make a good examination of, especially if you have someone at your company who's very familiar with that. Finally, you want to consider, and this goes to mitigation as well, you want to consider putting the original appraiser and his or her E&O carrier on notice. Now, their E&O carrier doesn't owe a duty to you. They owe a duty to the appraiser. So you want to set that up to say, look, if indeed the appraisal is bad, it was your fault and your insurance should cover it. And one of the quickest ways to knock out that claim or to defeat that claim that you want is to put it in terms of fraud, because errors and omissions coverage does not cover fraudulent intentional actions. So you always want to be careful when you're going after a third party to phrase things in a way that doesn't say only that they're negligent, but it puts it that way so that at least if there is insurance coverage, you're able to reach your hand into another pocket. And, if indeed, let's say the appraiser did commit fraud and they don't want to pay for their defense, they don't want to reach into their own pocket. If it's phrased as negligent and the insurance company fails to help them, well, then the appraiser or the other insured would have a potential action against their insurance company. And so even though they don't owe the duty to you as a third party, at the end of the day, you can find a way to leverage them, needle them into, helping out. Next slide, please. Okay, so back one. One more, I think. Okay. All right, so there we go. So let's talk about, we already mentioned how the appraiser going after them if there's an appraisal issue. Well, here's a list of different parties that tend to be the usual suspects, brokers. The first people we look at when we receive a repurchase demand, assuming this is a brokered loan, is the broker. Because many times the brokers will have a broker agreement with you that is similar to the one that the MLPA that you have with the investor. As they say, proverbially, it rolls downhill. So with brokers, one of the things that you want to do also at the very front end when you have a new relationship with them is you want to make sure that your broker agreements are tight. Whereas when I'm negotiating an MLPA for a lender client, and I'm asking for this exception, that exception. Well, I'm doing the exact opposite when I'm negotiating with a broker, unless I tend to be representing that broker. But you want to go ahead and make sure that their obligations to your company are no less than the obligations that you owe to your investor, and give yourself some additional peace of mind. So you want to make sure that the brokers you deal with, you have a good, solid broker agreement. You want to look at, the type of company that you're dealing with. Are they a fly-by-night place? Are they going to be here? Are they just shotgunning loans and you'll never see them again? Be careful who you do business with. We already talked about the appraisers. What about borrowers? Well, borrowers are very tricky to deal with. Many of them don't have the necessary funds to deal with these issues. There's a lot of concern over compliance issues of going after a borrower, saying the wrong thing. If something ends up in litigation, then you could be a witness, or you most likely will be a witness. And so you want to be very careful with how you deal with borrowers. But nevertheless, borrowers many times will be more than happy to give you information about this appraiser, settlement agent, title company, real estate agent. Hey, they told me to do this. I said that was bad. They said, don't worry about it. Things like that. You want to lock down their testimony. Or let's say that there's a occupancy issue, that an investor says that the borrower never occupied the property as his or her primary residence. Well, the defense to the occupancy issue usually comes down to intent. Did the borrower intend to occupy the property as their primary residence at the time of origination? Look, if they have a divorce, they lose their job after a loan closes, that's not your problem. There was no misrep. They intended to occupy as they represented. Nevertheless, a fact of life came up and they couldn't. But if an investor reaches out to a borrower to get that testimony from the borrower, hey, I told the lender that I never intended to occupy this. This was supposed to be an investment property, regardless of what I signed on the 1003. Well, then you're dealing with an outright, problem. And it comes down to a he said, she said. But if they're the investor is simply looking at an issue of, hey, the borrower's not there, we did a drive-by, the utility records or this, that, or the other, they didn't occupy it. Well, you go to the borrower and say, look, they're saying that you never occupied this. You told us that you intended to occupy this property as your primary residence. If you intended to at the time, then no problem. If you didn't intend to, okay, well, that's fraud. I want you to be honest with me. Did you commit fraud? I'm not telling you to say exactly that, but I'm trying to be a little bit clear in the point of it. And most of the time, if they have half of mine, they're going to say, well, I did intend to, but this, that, or the other came up. And certainly you don't want to tell them anything to lie, but you want to let them know what's on the line without, threatening them. Okay. So that's what we look at with borrowers. They tend to be a great source of information. What about settlement agents and closing attorneys? Well, closing attorneys, settlement agents, they have been labeled as the gatekeepers of fraud in our industry. They're the last line of defense to these loans not going wrong. And what is important that you look at is that you have a good set of solid closing instructions, that you're working with these settlement agents who are backed by closing protection letters of the title companies, and looking at closing protection letters that are favorable. Next slide, please. Okay, lender insurance policies. One of the things that we start with whenever we look at repurchase demands and indemnification demands is, okay, what are our potential losses here if, push comes to shove, worst case scenario, and do we have a way to go after our own insurance if needed? Because you always have to worry about timeliness of claims. When do we need to make a claim? Can we do that? Or do we do it late and then we've got some problems? Lots of policies don't cover buybacks. They call it a breach of contract as opposed to negligence. But some do. And sometimes they do, and they put it under a reservation of rights. They say, look, it's questionable, but we will agree to this, that, or the other under the reservation that we don't get rid of our defenses to saying, look, this is not a good claim. You want to look at your E&O. We talked about the reps and warrants policy earlier. Is there an employee dishonesty policy? Is there a cyber policy with regard to, maybe there was a breach and, problems resulted from that? You want to make sure that you look at all those, you talk to your insurance broker so that they can help guide you through that process. Then you want to look at whether or not, let's say that your damages, again, are $20,000. And let's say you have a $100,000 deductible. Well, last thing you want to do is, even if you do have coverage, reach out to your insurance company, make a claim, and them say, hey, look, come back when your losses are greater than 100 grand and you've paid that. That's a problem. You also want to worry about, okay, do I, by making a claim, cause myself to incur higher rates? And maybe I'm going to do that without even getting a claim paid because of this, that, or the other reason. So always make sure that you have looked over your insurance policies. Make sure that you talk to your insurance broker to prepare yourself to make those types of claims, to go ahead and make sure you have proper insurance like reserves in place. Next slide, please. Okay. Title companies. They have been a great source of recoveries for us under not only the title policies, because most people think, okay, I make a title policy claim, they may go ahead and defend me in litigation for a title related issue. They may go ahead and correct the title. But what happens if, the title is technically good, but, their agent or the settlement agent went ahead and committed fraud? What if they failed to follow my closing instructions? Then you have, in some states don't, closing protection letters, which acts as an additional layer of insurance for you. Many of them say, look, we will not only correct the title, but we'll indemnify you for any harm or losses that are caused if the settlement agent acts in a fraudulent or dishonest way. Dishonest and fraud have different elements. Dishonest is easier to prove. But it has to be with regard to your documents and monies, which settlement agents are doing. Failure to follow closing instructions with regard to your documents and monies. Now, the problem with these closing protection letters is that in many cases, they have different timelines. Some say you need to make prompt notice. Okay, prompt is great. Lawyers love prompt. Or maybe they say you have 30 days. We don't like that because 30 days goes by very fast, especially when you get a new claim and you haven't thought about these issues. So you want to make sure that whatever title companies and settlement agents you're dealing with, you're looking over your closing instructions to set them up to trigger coverage and get yourself paid if there's a problem down the road. You're looking over the closing protection letters to see, is this a real policy or is this just, a bunch of verbiage that looks nice but doesn't do anything for me? So that's what you want to, be looking at when you're looking at a title company. Next slide, please. Okay, so getting to litigation and settlement repurchase claims. Look, investors often have the option of providing the originator with indemnification instead of repurchase. We talked about that a little at the outset. What I can say is that it's very important to really take a good, hard look at what's coming in. The investors, the allegations. Are they someone that is going ahead and getting trigger happy with litigation? Do you have a good relationship with them? Do you have good facts? Is there good law? And, a lot of times the starting point is not necessarily the law, although you want to make sure that you're dotting your I's and crossing your T's. It's really the business side of it. If you can get something done on the business side, that will help push you and catapult you into the future, maintain your relationship, get you a reprieve. Maybe you eat a small loss, but you're looking at a higher amount of profits after the fact. And then sometimes you say, look, I can't do business with you. You left the market. You have no incentive to treat me fairly. The losses here are, significant, catastrophic even. I'm going to go all out to do everything and anything I can to defend the company. And at the very least, let's say they're claiming, like in the Lehman cases, most of the claims that we had were in the millions. Well, at the end of the day, attorney's fees are definitely not inexpensive, but, let's say you need a break. You need to get your business up and moving. You need to make some money to deal with something. Well, you might be better off slow rolling that litigation as much as you can, because that will be the cost of putting this off for another year so that you can have the resources needed to resolve it. Again, you're trying to think outside the box, look at your particular circumstances. And of course, looking at the facts, looking at the law, having a good review done is always critical. Because if they say this was black and you say it was white and you've got evidence it was white, then, tell them to pound sand and good luck. But that being said, again, even if you have a good claim or good arguments and the investor sues you and you have a unilateral attorney's fees provision, well, then you're stuck in the position of having to hear from your lawyer, look, it's going to cost you this amount to deal with the case. You have a great case. I think we're going to win. But if you settle it now, you'll save yourself 80% of the money that you're going to have to spend, and you'll avoid all the risk. That's something that, it's never fun. Well, why the heck should I settle a case if I've got a great, set of defenses? Courts don't like to kick out claims on motions to dismiss right at the outset. So again, it really comes down to that cost benefit analysis and how you're managing that. And any attorney that's worth, that's looking out for your interests is going to talk about that in those types of circumstances. And they're just saying, look, cost benefit, this looks like it's going to be a better deal for you. Statute of limitations when it comes to litigation, that was a huge issue that was being litigated in the Lehman cases. And, we would go back and say, look, for the reps and the warrants, if they're ever violated, they're going to be violated at the time of origination. They don't get violated 10 years after the fact when there's a problem. Well, nevertheless, the court wasn't enthusiastic about that. And I think there's going to be some more analysis coming out of New York. But then you have states like with the city lawsuits in Missouri. I think their statute of limitations is 10 years. For things like breach of contract, whereas California, say, is maybe 4 years for breach of written contract. So you want to know the statute of limitations, and that's something that you want to talk with your attorney about to see, okay, this claim is so old. It's like the FDIC case cases that we're dealing with. How the heck can they come after me when this loan was originated 15 years ago? I don't even know this claim anymore. I have no evidence of it. There's nothing there. Well, when you're dealing with the FDIC, they have something called the extender statute, where they have a special benefit to going ahead and having an additional statute. So the FDIC, just while I mention them, is, I think they filed about 4 or 5 lawsuits now. They've gone after many people above and beyond the litigation. They said that their statute of limitations they believe is up some point this year. And, they really have nothing to lose, although, they would certainly like to get things resolved sooner. But in my estimation, with the claims that I've seen from them, we've dealt with them, back from 2007-8, when they were handling those failed institutions. They're coming out there like a bankruptcy. They're looking at just trying to maximize the money that they can get. So if you have a good resolution for them, not too much money's on the line, then it might be worth your time to settle. But if they're asking for millions of dollars and they don't have a good set of facts, well, you should push back. At least that would be my recommendation and advice to a client if they were to come to me on that. Okay. Challenge the loss figures, when they come back and it's not a repurchase and it's in the indemnification stage and they're saying that they suffered this loss, well, be critical of it. Look at it. Did they fire sell the property? Did they get the fair market value for the property? What have they done to go ahead and mitigate their losses? Because you can pursue people for breach contract, but every state has an implied a covenant of good faith and fair dealing. And if they're going to pursue you for damages, well, they should be made to answer to, okay, you're saying you lost this, but did you take the appropriate, reasonably necessary steps to minimize your losses? Or did you just fire sell the thing? Look, I'm going to roll this downhill. I got a claim under my contract. I don't care what I lose now because I know that they're in business. I'll take my money from them. Well, that's not the way it works. So you want to make sure that you put them through their paces to justify that. Okay, global settlement. I mentioned that at the beginning. If you have a lot of claims, it's better to go ahead and try to resolve them all at once if you can. And not only that, well, most investors won't go ahead and say, okay, well, you pay me this, and then I'll waive any claims or I'll release you from any liability on any claims on any loans you've ever sold to us up to this date. Generally, they won't do that unless, there are circumstances they will. But one of the things that you can require in the contract is you say, okay, we're only going to settle these 10 loans, but the last thing I want is to settle these 10 loans, pay you X, and then have you come back to me on another 2 or 3 loans. What good is that to me? And so what you say in there is not necessarily that they waive any or they release any and all from, throughout history, but they say, you're settling these 10 loans and anything related to them. And I am not aware of any other loans that we're actually going to send back to you or that we may be sending back to you specifically. And then that way, if you resolve those 10 loans and they come after you for another 2 or 3, and they knew that they had these kind of just waiting in the wings, they wanted to soak you for a little bit of money and then push those, well, then you have a defense. Hey, you said that you were releasing any ones that you knew about. And, well, you knew about these other ones, and I'm sorry, but I'm not going to pay anything on those. So, that's when you're looking at settlements and negotiating. Next slide, please. Okay, so it looks like we are at our hour mark. Nevertheless, I put together a whole section here on evolution of agency reps and warrants. A lot of people ask about how to deal with those agency claims and what about the protections that were issued. So I laid this out for you. And, if there is any follow-up questions, I also have some other material that I can send to you, but I want to be respectful of everyone's time. And so what I would say is that not only on the evolution portion, but let's say you have questions about anything that has come up throughout this discussion, this webinar, please feel free to either reach out to Tom Gallucci or myself. I'll be happy to address those. If Tom provides me a list of questions from the audience, I'll go ahead and put together an FAQ, and we'll send it out to all the registrants of today's webinar. But again, if you are a member, please know that you do have the ability to have 2 30-minute free consultations. If you're already a client of ours, we'll be happy to apply that to you. But all that being said, I want to thank everyone and thank the Mortgage Collaborative, especially for allowing me the opportunity to be on this webinar talking with you today. So thank you.
Well, James, thank you as well. We always appreciate your insights and your expertise on a lot of these timely topics facing our members within the network and our industry as a whole, too. So just as a reminder to the attendees, you'll get a copy of the deck that you saw today in follow-up to the discussion, as well as access to on-demand assets from today's discussion, too, in case there's individuals within your organization that weren't able to attend and want to see it. We'll have it accessible on our YouTube and podcast channels as well. So James, as always, appreciate you. And last thing, attendees, we'll also put that registration link for our upcoming webinar with Johnston Thomas in the month of February, in that follow-up as well. So we look forward to seeing you next month there too.
Right. Thank you.
Have a great day, everyone.